Don't hate the player, hate the game. I got the Hermès lawsuit right here, and we're gonna get into it. Greetings, Luxe lovers, welcome or welcome back. So this is hot off the press, and we're going to delve into this lawsuit together. And I preface this by saying that I'm not a lawyer, and all of this is alleged and for entertainment purposes only. But I simply could not resist reading the actual lawsuit and giving my Luxe-loving opinion. In fact, I addressed some of these points in my previous video about Hermès secrets, and I'll put that link here, where I addressed my surprise that Hermès hadn't been sued yet. And here we are. Because frankly, I thought they were doing some odd things online, and I thought they were protecting themselves from lawsuits. So check that out. But let's focus on this lawsuit that just came out on March 19th. So when I first saw the article on Purse-Bop, which I'll link below, I was shocked to see that yes, Hermès is facing a class action lawsuit for its alleged tied purchasing practices. So today, I'm just going to react to what I read in the actual lawsuit. I'm basically going to go through from a novice lens and read through what I'm seeing and give you my thoughts at the end. So this is in the Northern District of California, but it's these two people against Hermès International and Does 1 through 10. So I can only imagine that Does 1 through 10 are people like store associates. At its core, this is saying that this is an antitrust and unfair business practice class action lawsuit against Hermès. And the plaintiffs, or the people bringing the lawsuit, are seeking compensatory and punitive damages and appropriate injunctive relief. So that basically means, I think in my understanding, is that they want money and they want a court order for Hermès to stop its, quote unquote, alleged antitrust unfair business practices. So the lawsuit goes into talking about the parties, and it lists them all by name, and it talks about the jurisdiction and venue, so again, California. And then it goes into the section about factual allegations. And there's actually an interesting little part about the history of Hermès. And then section B is all about the Birkin handbag. Now, I guess if you're some fancy law firm, you don't know the ins and outs of Hermès products, but what struck me odd about this lawsuit is that it is actually considering the Birkin and Kelly handbags collectively as the Birkin handbag. I'm not sure why they would lump together Birkin and Kelly handbags as the Birkin handbag, but just know that whenever they say the Birkin handbag, they're really talking about the Birkin and Kelly. Also, the other weird thing about this lawsuit is that as you go through the actual text, they will talk about Birkin handbag, but sometimes Birkin is spelled wrong, like B-E-R-K-I-N. So clearly whoever wrote this isn't a luxury aficionado. They're just some lawyers in it for the deal. But they go on about how the leather section is one of the highest growing sections, and they're basically alleging that there is this quote unquote tied spend so that customers are coerced, their words, not mine, coerced into buying other ancillary products, things like home goods, etc., in order to be offered a Birkin. The other weird thing about the claims in this lawsuit is that they are saying that customers can't walk into an Hermès retail store and pick out the Birkin that they want and purchase it. And that's absolutely true. But then further on down in the paragraphs, it says that customers cannot order a Birkin bag at the retail location. There's no way to order a bag in the style, size, color, leather, or hardware that a consumer wants. However, we do know that there is something called a special order, so I'm not sure if they're gonna get nitpicky about, how true all of these statements are, but I just find it weird that they would make a fuss to say that you can't make these orders, where in the luxury community, we know that that's possible. However, it isn't offered to everyone, so I would think that they would wanna put that in the lawsuit as well, that it's possible, but not everyone can be offered that service. It also alleges that once a consumer has a sufficient purchase history, that the consumer will be offered the opportunity to purchase a Birkin handbag. But what they never talk about is what defines sufficient. So I feel like that's a bit of a gray area already. Then there's an interesting section on page 7, which talks about the commission structure that the sales associates of Hermès work through. And what's fishy to me about this is, how did these plaintiffs get the commission structure? To me, that's like proprietary information from Hermès in their practices. So it's weird to me that they would bring up in a lawsuit information that's frankly private to the company. But basically they're saying that sales associates are paid 3% commission on these ancillary categories like scarves, belts, and jewelry. And they're paid 1.5% commission on non-Birkin handbags, and then 0% commission on the Birkin handbags. And a lot actually hinges on this incentive structure, and we'll come back to it later. But I feel like all Hermès has to say is, no, that's false. And then their whole argument is blown out of the water. The document then goes on to talk about the specific times that these two plaintiffs went in and asked for a Birkin bag, and they were basically told no. For the second plaintiff named in the lawsuit, apparently this person went in and made multiple attempts to purchase a Birkin bag. On each occasion, he alleges that he was told he needed to purchase other items and accessories, but he was not able to purchase a Birkin bag. And then on page 8, they talk about the definition of the class, and I thought this was interesting. This is basically all residents in the United States who, in a given period of time, purchased or were asked to purchase ancillary products in order to purchase a Birkin bag. Now, I can tell you with full honesty that I was never instructed by any of my essays, and I do have 2. I was never instructed to buy any ancillary products in order to buy any of my Birkin. And for the record, I have 2 Birkins, a Kelly, and a Constance, and some other non-quota bags. So moving on, further down in the document, they talk about the different claims that they're making, and basically they are claiming that the practices of Hermès are in violation of the Sherman Act and are in violation of the Cartwright Act, and these are various antitrust type laws. They definitely do double down, and here it says that the defendants, i.e. Hermès, have unlawfully tied their Birkin handbags to their ancillary products through their sales associate incentive program, and that they willfully and intentionally engaged in predatory, exclusionary, and anti-competitive conduct to maintain its market or monopoly power. I also think it's weird to claim that someone has monopoly power over a product that they produce. Like, when I think of a monopoly, I think about broad categories, but not a specific handbag. It's not like Hermès owns all handbags in the market, it's just a particular one. I personally feel like it's Hermès's right to be the sole creator and seller of the Birkin bag. It's their invention. And then at the very end, it says, under the prayer for relief, basically this is, what do these people want? Basically, they want restitution and damages for what's been done to them. So they want money. And they want Hermès to stop engaging in their practice of this alleged unfair treatment of customers. They also want to be repaid the attorney's fees if they win. So that's basically the rundown of what's in this lawsuit. Again, I'm going at it through my regular old person lens, but I did have some thoughts in the end. First, I personally think it's hard to prove in a court of law that this is company policy, unless these 2 plaintiffs come like literally with a training manual that says that this is something that Hermès corporate has trained them to do, to say that this amount of money or purchasing these items equate to a Birkin or a Kelly bag. I think it's very hard to prove that this is a practice that can be stopped. Also, as I said, in all my years of buying from Hermès and buying quota bags, no SA has ever said to me specifically, you need to buy from these categories in order to get a Birkin, or anything like that. And I've heard stories that in other countries this has happened, but that just wouldn't apply to this lawsuit because it is in the United States. Second, I actually don't think that the sales associate commission structure has any bearing on proving that the sales are tied. It just outlines that basically these quota bags sell themselves. So Hermès chooses not to provide a commission on something that everyone wants. What they are incentivizing is for the sales associates to work harder to sell other items. But to me, the logic doesn't hold in that the incentive structure proves wrongdoing in any way. Also, I wonder if this information is even true. Like, all Hermès has to do is say, that's not right, and basically the logic falls through. And isn't this proprietary? How did they get that information? Can they use information that's been obtained illegally against the firm? And third, the United States is pretty notorious for favoring the side of private corporations as long as they're not discriminating against a protected class like race, gender, ethnicity, etc. And because this case doesn't even touch that, I think that Hermès can defend itself in selling certain items to those with a purchasing history because they're a private corporation. Also, if tide sales were real and it was very clear to everyone that you would have to spend, say, $30,000 to get a Birkin or a Kelly, I think Americans would actually appreciate that transparency and spend that $30,000 to get Birkin. So if tide sales were real, I feel like we'd see a lot more store-bought Birkins and Kellys out there. I personally think it's the inconsistency that seems to drive people nuts. And let's say these allegations were true. It would be ironic that Hermès' defense might say that they only do this tide sales to avoid selling quota bags to resellers. However, it's the actual practice of restricting the sales that drives up the resale value. So in a way, it's a chicken and the egg argument. Put another way, if quota bags were just readily available for sale, the hot resale market would then totally drop off, and there would be no need to guard against the resellers. In the end, I personally think the plaintiffs will not win, and that Hermès will continue on as they do today. I'd love to know in the comments what you guys think. And also, in the end, it says that there is a demand for a jury trial. So the plaintiffs are asking a trial by jury. Who's in for that jury duty? Me! I hope you subscribe to see how this unfolds. Bye!